Welcome to Law in Layers, where we break down the law one layer at a time. Today, we'll be breaking down the basics of robbery. Robbery is defined under Section 8(1) of the Theft Act 1968. It states that a person is guilty of robbery if he steals, and immediately before or at the time of doing so, and to do so, he uses force on any person or puts or seeks to put any person in fear of being then and there subjected to force. In simple terms, robbery is theft combined with force or the threat of force. This means that before someone can be guilty of robbery, the prosecution must first prove all the elements of theft, alongside the use or threat of force. The Actus Reus of robbery consists of the Actus Reus of theft, combined with the use of force, or the threat of force, against any person, either immediately before or at the time of the theft. The first element to consider is the Actus Reus of theft. This is made up of three parts: appropriation, property, and belonging to another. If you would like a more in-depth explanation of the Actus Reus of theft, watch my video linked above. The second element is the use of force, or the threat of force. This force can be minimal, it does not need to involve serious violence. Even a small amount of physical contact may be enough. A key case example is Dawson and James. In this case, one defendant nudged or pushed the victim, causing him to lose his balance. This allowed the second defendant to steal his wallet. Both defendants were convicted of robbery and appealed, arguing that the level of force used was too minor to amount to robbery. However, the court upheld the convictions. It confirmed that even slight force can be sufficient, and importantly, whether force has been used is ultimately a question of fact for the jury to decide. The force may be applied either to a person or to property. For example, even grabbing a shopping basket from someone can amount to robbery, as seen in Clouden. However, some level of force is still required. Mere touching will not be enough. This was confirmed in RVDPP. Importantly, robbery is not limited to the use of actual force. Fear of force is also sufficient, meaning it can be enough that the victim is put in fear of immediate violence. Finally, the force must be used to facilitate the theft itself. In other words, it must be used to carry out or complete the stealing, not just as an unrelated act. Under Section 8, the term any person means that the force or threat of force need not be directed at the owner of the property. So the force can be against the victim, a bystander, a security guard, a shop employee, or anyone else present. As robbery requires that force is used in order to steal, the use of force must precede or coincide with the theft. A key case example is R. v. Hale, where the Court of Appeal held that theft can be seen as a continuing act, meaning that if force is used during or immediately after the theft to secure the stolen goods, it amounts to robbery. Once the prosecution has established the Actus Reus of robbery, they must then prove the mens rea. This is the mental element of the offense and requires more than just the intention for theft itself. For robbery, the defendant must not only possess the mens rea of theft, but must also intend to use force, or threaten force, in order to steal. Importantly, the force itself does not need to be severe, but it must be directly connected to the stealing. A key case is R. v. Vinall. In this case, two youths punched the victim off his bicycle, chased him, and took the bike, which was later found abandoned nearby. The Court of Appeal quashed the robbery convictions. Although the defendants may have been guilty of assault and potentially theft, the prosecution could not prove that the force was used with the intention of permanently depriving the victim of the bicycle. If you would like a more in-depth explanation of the mens rea of theft, watch my video linked above. If both the Actus Reus and mens rea are satisfied, the defendant will be guilty of robbery. Robbery is an indictable-only offense, meaning it must be tried in the Crown Court. The maximum sentence is discretionary life imprisonment as stated under Section 8(2) of the Theft Act 1968. Thank you for watching Law in Layers. If you found this helpful, make sure to like, comment, share, and subscribe. I'll see you next time, as we continue to understand the law one layer at a time.